everybody. It is good to see you all. I cannot believe we are 1 week out from the end of our class. We're going to have, I just want to start by clarifying that the exam will be ready after class next week. And then you can take it anytime before the end of the exam period. I desperately urge you to reach out and tell me whatever you need. It is my job. I hope I've said this enough, but I view it very strongly as my job to get you exam ready by the time you leave this class. This should not be the cram exam where after the class is over, you try to figure out what the heck we just did. So please reach out to me if there's anything that I can do. I'm happy to set up reviews. I'm happy to go over practice questions. I'm happy to do office hours at different times, more times, conferences, whatever it is that you guys need. The one thing I do suggest, although only suggest, oh, thanks. Nathan's answering your question. Actually, nice. Thank you. The one thing that I want to suggest is that you consider, so our new week rolls over on Sunday night. So Monday we start our final week. I would encourage you to think about trying to do that work on the front end of the week so that in our final lawyering lab, we're able to go over all of that material. It's visitation that you're studying next week. So give some thought to maybe trying to resequence your week if you're someone who's usually doing the work on Saturday or Sunday. Maybe try to push it up a little bit earlier. You certainly have until Sunday night. But I personally think it would feel better on our last day of class live if at the end you're actually done with the class. Otherwise, you'll kind of, eke into Sunday, and then you'll start to think about getting ready for your exam. I want to touch base very briefly on two current events that I think are worth noting. So I'm going to show first, this is just a news story from the Washington Post earlier this week, and really grappling with the question of what they call childcare deserts, and particularly highlighting the ways in which childcare has been affected by COVID. I think it reports that something like 85% of childcare facilities closed during COVID, and only a small portion of them have opened back up at full capacity. And they were already struggling to keep their doors open. As we talk about child care this week, and we talk about what's in the best interest of the child, and we think about options, I want to just mention how incredibly hard this is going to be for families to manage, and to highlight how race and class are affected here. So here, for example, is an overlay of two maps together. The one on the left is talking about where there's an absence or a deficit of childcare options. And then the one on the right is talking about where the population is the highest percentage of Black community. And this is in Detroit and its suburbs. And you can see a really stark overlay there. So I want you to keep your eye carefully on this issue as it affects Kentucky, and it's particularly rural families and middle and lower class communities that the court is that the media is noting in that article. Elizabeth?
Yeah, I was just going to provide an anecdote. There's a Facebook page called Mothers Esquire, and one of the mothers was just posting about having to have her small child in a depot online, because there's no childcare, and it's just it has really come to the forefront how much parents struggle with childcare.
Absolutely. Thanks so much for sharing that. And this is only going to become an even bigger issue as we move into the fall and we think about schools possibly, and hybrid models and things like that. And then the second news story that I want to share, just to keep us focused on current events, is actually an article by Dorothy Roberts. And I mentioned her a couple of weeks ago again, but I want to draw your attention to it because one thing we don't talk about in this class, and we should, and in a full 14-week class we would be child abuse and neglect and the power of the state to intervene in families to address potential and suspected child abuse. And so this is an article, and I'll send you after class links to the full text of both. But this is an article by in which she's arguing that we want to be careful, like regardless of politically what you think about the defund the police movement or this idea of reallocating resources. One of the things that we talk about so often is the idea of reallocating to social workers and reallocating to other structures that we have. And so in it, she says, look, let's be clear that the child welfare system has always been a racially punitive class. It's been punitive on families of color, on economically distressed families, and it's been a tool of removing children. It's been, we have grossly disproportionate rates of African American children, particularly in the foster care system, who aren't making their way out or who are taken from their parents in parental interventions. And so she cautions here and says, we want to be really careful as we talk about systemic and structural racism, that we don't just move from one racially critical, one system that's racially flawed to another. And so she's cautioning here that as we hear all this talk about, let's just send more social workers in, let's use these other systems to intervene, that we should be careful to to critique thoughtfully these other systems as well. So I'll send that to you, but I think it's a nice thought-provoking read, and it gives you a little bit of a critical race perspective on the child welfare system. So as we get started tonight, I will start by candidly saying that I have about 3 classes worth of material packed in for 75 minutes, which is now like 67 minutes. So we're probably not going to get through it all. So after class is over, I'm going to quickly look ahead at next week and reassess. So don't get too far ahead, because I may cut something for next week, because it's very important that we end when our class ends and we don't have any carryover. So I want to just alert you to that possibility. We're going to talk about parentage tonight. Parentage is my favorite unit of the whole semester, and it's especially my favorite unit to end on because it opens up so much possibility for you all. And so if we think about where we are historically, we are going to study today a huge range of approaches. The idea, this is the one unit, you can tell if you look back on our last 7 weeks, every unit, I've really tried to build historic depth and then modern clarity. But here we're going to build historic depth, and the modern clarity is completely lacking. There is so much happening in this area, and a real huge momentum for law reform at the state level. So I want you to keep your eye on this. These are things that you very well, any one of you could be litigating the next case that challenges Kentucky's parentage laws. So if you look at it here, look at the range of things we're going to talk about tonight. The idea that we could establish parentage by biology, which historically wasn't possible, but is entirely possible now. But even that can be super complicated and confusing. There was a really great story a couple months last spring about a parentage test, a genetic test that revealed that a child had actually had a twin in the womb and had like DNA from this other twin. Like, even there, it wasn't super clear how our DNA works and the ways in which we can have issues with even just biological testing. We can think about parentage through the lens of conduct, like birth or marriage, or social parenting, like who actually puts the kids to bed at night and takes care of them regularly. We can look at parentage through the lens of intent. We can look at it through the lens of contract, through things like adoption, and we can look at it through the lens of judicial determination. And so that's a huge range of approaches. And the problem is almost no one of any community or any level of scholarly expertise on this can really say that any one of these approaches is the right approach always. Rather, we can all come up with examples where one approach might be better than the other. Notably, what's not on my list here is the best interest of the child. The way we think about parentage is not framed by the starting point of what is in the best interest of the child. And we want to critique that and talk about that a lot tonight. So instead, what we're going to study tonight is a historic context where we figured out who a parent was. You became a mom by birthing a child. You became a dad by being married to the woman that birthed the child, which means, I hope, jumping off the page here is the reality that means if nobody was married to the woman who birthed the child, there was no legal father historically. And so then we're going to move to modern approaches, which are still going to heavily position motherhood around birth. We're going to expand fatherhood to marriage. We're also going to expand it to acknowledging paternity at birth and to holding the child out as your own. And then the very last thing we'll end probably tonight with is this idea of why are we at all delineating between motherhood and fatherhood? Why are we not just framing parent-child relationships without regard to gender? And so Kentucky is sitting much closer to these historic approaches. And Kentucky has, almost like most states, has a lot of work to do to reframe how we think about parentage. Only 3 states have currently adopted that modern Uniform Parentage Act that you studied today. Hello, we'll come back to you, Kim. Okay, so let's go ahead and get started. But I think this is a fun unit. You can expect to see this tested. You'll be tested on either the original UPA or the modern UPA. And so we'll talk about that in a moment or throughout class as to what that will look like, because I want to make sure we're really crisp on what you need to know for exam purposes. So let's get started, though, with Clark v. Jeter. And Allison, I have you first. So why don't you tell us what the statute was and what happened here?
Okay, so in Pennsylvania, there was a statute that said if 2 people were not married, then there was a 6-year statute of limitations on when you could petition the father, basically for like child support obligations. So in this case, Sherilyn was the mother, and 10 years, I had to double check that math, that's sad. 10 years after having the child, she petitioned the alleged father to have a blood test because she was asking the court for support payments. They found that there was a 99.3% chance he was the father, and he motioned the court to dismiss on the grounds of statute of limitations being exceeded.
Great. And why did they even have these statute limitations? What was the historic reason? It's really helpful to get our bearings here because we all think with modern technology in mind.
So I'm trying to find the exact language. Basically, Pennsylvania said that they were worried about fraudulent claims after 6 years, and also, what was the other reason? Avoiding fraudulent or stale claims, and there had to be a reasonable opportunity for the parent to present the interest of the child was the other reason.
Good. And in order to really understand those reasons, it's really helpful to think about the world before we had DNA tests. And I was prepping for class, and my kids started singing that song when they heard me talking. What's that song? I just took a DNA test. Yeah. Lizzo. Anyway. We didn't have DNA tests before, so the testimony historically would have been much more specific, right? On what days were you with her or him, what days, and how many months ago was that? Were you with anybody else? Those kinds of facts are much more likely to get stale over 6 years or over 2 years or over 3 years. Of course, when we're talking about a DNA test, we aren't so concerned about the stale or fraudulent nature of it, but we would have been if you can rewind yourself to a world before you could take these more simplified genetic tests. And so, Michael, let me bring you in for a minute here. Let's talk for a second about why the heck. So Allison tells us 10 years. So it took 10 years for mom to petition the court to get a child support order against dad. Why in the world did it take that long? And we don't really know here, but let's speculate, Michael, or really anyone. What are reasons why she might not have asked for this sooner?
My first guess was maybe financially, maybe she couldn't afford it. Again, it wasn't stated in here, so who knows what it could have been. But maybe she didn't know her options. Maybe she thought that she was going to get married to him in the future and she wouldn't have to deal with any of this. But I'm sure there's plenty more to it than just that.
Good. And maybe the other way for the expenses, maybe she didn't need the money early on and then something changed and now she needs the support because she's trying to get money from him now to help. So maybe she was financially more okay before, or maybe they might have even been together, like you said, for some of that period of time. What else? Someone else jump in, and someone jump in who's far more pessimistic and jaded. Allison, bring it.
I heard pessimistic and jaded, and I was like, that's me.
I do too.
So honestly, I mean, maybe she was in a relationship with somebody else at the time and they were together and then they ended up separating. And then he wasn't the biological father. And so after 10 years, she needed that financial support and she reached out to try to have the biological father support.
Did you know that, or did you just watch a lot of television?
I think I'm just that cynical.
You are exactly right. So the official reason, so it's 10 years that went by. The real reason why she waited 10 years is for 8 of those years, she was living with another man who believed he was the father, and that man was helping to provide support. And then over a 2-year period of time, the person who believed he was the father left. And then she set out to try to find who she knew was the real father and to try to secure support from him. And I want to mention that because we're going to talk in a minute about this holdout exception, that if you hold out a child as your own, you will be found to be the parent, even if you later find out that you were wrong. And so here, if the other father had actually wanted to stay in the picture, we would have had something much closer to a Michael H. kind of situation. But here she unequivocally led someone else to believe that they were the father. And so now it's 6 years in and she's petitioning. And I want to make a really important point that is sort of subtly gestured to in the readings, but needs to be said with like glaring, honking red lights. If you are a mother or a parent rather, and you want to receive any public benefits for your child, you cannot at all receive public benefits for your child without establishing paternity or taking steps toward establishing paternity. So that's super important because if this mother did not need public assistance, she would have the choice to choose whether to seek support from the biological father or not. If she needs public benefits, she doesn't have the choice. In order to get those benefits, the state, not mom, will start to pursue the parentage proceedings to try to figure it out. So on her paperwork to obtain public benefits, she would have to reveal the name of the believed or the purported father. That is a huge point. If you want to think and talk about this Dorothy Roberts point about the role that the state, that the family law systems play in certain communities and in particularly lower income families, that is an incredible power that the court is playing. And it takes entirely the autonomy of mom here away to be able to make these decisions. So if she wanted public benefits, she would have had to have started these proceedings. And that's a super important point for understanding a combination of both child support and parentage. So Michael, let me come back to you. So what happens with her, what actually happens with her claim procedurally?
So,
what happens after the file? Yeah.
So when she got to the trial court, they upheld that statute of limitations and she was denied. She then appealed to the appellate court. But before that case was decided, the legislature enacted an 18-year statute of limitations for actions to establish paternity to comply with Federal Child Support Enforcement Amendment of 1984.
Good. And those federal child support changes were related to welfare purposes. It's trying to reimburse the federal government. And this is like a huge point to understand. The federal government doesn't actually care necessarily about finding that father or the second parent. What it cares about is being reimbursed. Because if those public benefits are coming out, the check that dad will owe for child support will not go to mom. The check will go to the state. And that's a really important point to see the power of the public welfare system shaping parentage law. So Liz, let me come to you now. So what is the legal theory that that she brings here? Two legal theories, actually.
I don't understand the question. Sorry.
What cause of action? So she's trying to strike down 6-year statute of limitations. What legal theories does she use to try to say that this provision is unconstitutional?
That it. Goodness, where did I write this? That it violates the. Oh my God! Equal protection clause and the due process clause.
Good. And under we'll take them each in turn. Just a quick question under the equal protection clause. What's the classification? A review here. Anytime we have an equal protection issue, that means there's a classification. What's the classification and what standard of review does it get? It's new for us.
Is that the intermediate scrutiny one? Okay.
Good. We're going to get intermediate scrutiny. Why? Because what's the classification based on?
It's based on sex or illegitimacy of the child.
Good, absolutely. So make sure if you go back to your notes from weeks 1 through 3, I kept putting that chart up on equal protection that said on that intermediate scrutiny, sex or legitimacy would both get you intermediate scrutiny, but this is the first case where we properly study it. The history of treating children with animus and discriminatorily because they were born out of wedlock. The whole history of this is a loss of inheritance rights. It's a loss of support rights, no legal obligations or relationship with the child and the father, the huge history of, quote, bastardizing these children. And so the court, because of that history of animus and discrimination, is going to apply heightened scrutiny. It's going to look much more carefully at any classification on the basis of marital status. Next, Liz, you said the second claim is due process, and you're exactly right. Is that, though, the substantive due process we've been studying or a different kind of due process?
Different.
Yes.
Sorry.
Channel your inner Les Abramson here or your inner Dan Cannon.
Oh goodness.
Michael or Allison, do you want to jump in and help out?
Is it procedural due process?
Good. Procedural due process. And what does that mean? We've spent so much time learning substantive due process. We might forget that procedural due process is the more obvious and more common. What does it mean?
I said I did not know that was a thing, so that's okay. Okay, cool.
Think about, do you guys cover the Kelly v. Goldberg case and Civ Pro? I think that's the case. Matthew v. Eldridge. Do you guys cover that in Civ Pro? What's that?
We cover them in con law.
Oh, okay. Okay, so not everyone's had con law. So Tanner, why don't you, I think I have you next anyway. So why don't you jump in and just help us understand what is procedural due process generally?
So procedural due process is the process that is due to you as someone who is having a right infringed by the government. So it's usually notice and hearing.
Good, perfect. So ironically, we've spent so much time understanding the hard version of this, the substantive due process, that the procedural seems hard, but it's actually the easy and obvious one. So procedural due process means before you take away someone's right or infringe on someone's fundamental right, there need to be certain procedural protections in place. And so here, if you're going to make a procedural due process case or issue in family law, you would be citing some procedural protection that's missing that should be there. Not having a lawyer, having a right to a hearing, having appropriate statute of limitations, having a jury, something procedural. So it's not substantively about the right to parent or the right to marry. It's procedurally about making sure you get it right procedurally. And so here, so anytime you do an analysis like this, you would be looking for the exact procedural omission that you think is constitutionally problematic. So here, the procedural omission is the statute of limitations, that the complete cutoff after 6 years of anyone able to make this case is a procedural due process violation. So Liz, let me come back to you. How does the court work through that equal protection analysis?
How does
Is we need an important government interest? What is
yeah, so they said like it has to be substantially related to the government objective, and that placing a limit on the statute of limitations should only be done to avoid litigation and must be the reasonable amount of time. But then they use that Mills case saying that it's really not a reasonable amount of time, and also proving paternity isn't as hard.
Good. If we take it through our two-step test, the first question is it an important government interest to, ensure that we, don't have stale or fraudulent claims? And the court's kind of a little iffy on that and says, we'll let that slide for now. But as Liz mentions, when it gets to the point about are the means a complete cutoff after 6 years substantially related to preventing stale claims, the court says no. And so here, this case, I spent probably way more time than I should have on this case, but it does reveal for us a little bit about the power of the state. It reveals a very significant change in approach happening in the 1980s, particularly bringing the federal government into child support, using child support then to shape parentage. And we're all of a sudden starting to embrace the idea of figuring out who non-marital fathers are. But it's not because of the best interest of the child. It's not because of some altruistic goal of giving non-marital fathers equal rights and access to their children. It's really a much more crass purpose to make the government whole for the public benefits that it expends on children of single mothers. And so 18 years is the statute now. Let me come to Brian for a second. So what I'm going to sort of pivot a little bit and do a little bit of a role play here. So in Clark v. Jeter, that first father, so the father who was with mom at the moment of birth, was actually bedside. When the baby was born, this first named father believed that he was the father. And so I want to use this as a moment to highlight voluntary acknowledgments of paternity. So I'm going to put up on the board here a voluntary acknowledgement of paternity. It's a little hard to read here, but it's basically saying, I understand that signing this makes me a father with judicial, as if the weight of a judicial determination. Brian, let's imagine that you are the lawyer for the first named father, and he calls you bedside as she is having this child 10 years earlier. What would you need to advise him about signing this document? Break it down for us.
And if he's seeking to keep custody is the scenario.
So he's bedside and he thinks this movie is his and he's stoked and it's beautiful and he's got a flask ready to celebrate his baby being born, but he doesn't actually know, but he's happy and blissful. So
he, by filling out this form, according to a 1992 or a 1993 Omnibus Budget Reconciliation Act, it would create a rebuttable presumption that he is the parent. So if he wanted to maintain custody of that, he could sign this and it would carry equal weight with the judicial determination. But at the time this case occurred, that was not the law. So that would just be like about 1992 or 1993 onward.
Good. So let's imagine, though, that this was the law. What are you going to tell him? Should he sign this?
Yes, if he wants to maintain custody, because the other outside party would have to meet that rebuttable presumption to determine otherwise.
So any of my cynical and jaded folks, again, you're correct, Brian. He should definitely sign it if he wants to keep a lifelong relationship with this child. But someone, DJ, hopefully more cynical and jaded, as his lawyer, what do we need to say to him? It's ugly, but say it, DJ.
Unless you want to be tethered to a child that actually isn't biologically yours, don't sign it until you know for sure.
Yeah, do you see the pickle that we're putting putative fathers in? The fact that a man, I suspect there's not a single man in our class who has ever been bedside by a woman giving birth who didn't think he was the father of the child being birthed. There's not a lot of bedside men who just hang out for moral support, right? Like the fact that he is there, he believes he is the father. And so Brian very graciously goes with him in that direction and says, well, sure, if you want these rights, here's your chance. But the problem is what DJ just says. We, as the lawyer of this man in this situation, need to say explicitly that he's effectively waiving his right to have an actual genetic test. And if you want to talk about the coercive power of the state, like, first of all, just look at this document. Like, even as second and third year law students, it's not a user-friendly document that says it. What it actually says is signing this agreement establishes the paternity of the child has the same force and effect as an order of filiation entered after a court hearing, including an obligation to provide support, except only if this acknowledgement is filed with the registrar or like this language. I guarantee you, 98% of fathers who sign these either don't read them or don't even know what they actually mean. There's no counseling connected to it saying that you're not going to be able to rescind this after the limited period of rescission has passed. And we basically have taken away all of the procedural protections that might come from a court proceeding and put it in the most emotive moment of a putative father's life, standing bedside. And people sign these all day long because they don't really realize what this actually means. But what he's actually signing here is a commitment for 18 years of support, and it does not care that he might not be the genetic father. And so this is an incredibly fraught document. They are used, I will not ask you, but I can tell you these are used liberally in hospitals. And they're presented, if you've ever been at a hospital for any medical procedure, you know how many forms you sign, waivers, this, consent, that, paper flying around you. And if you're bedside at with a woman that you have enough trust with to be in the room with her while she's birthing, this document is a very fraught context. But what it is trying to do is shortcut or circumvent the judicial process. And these documents go on to hold the weight of a court determination of parentage. And as a practical matter, it is ever so slightly rebuttable. But the best way to summarize the context is it's only rebuttable if the biological dad shows up and wants to take on those support rights. But it's not rebuttable just because he finds out at year 8 that this is a Kanye song, right? 18 years, you find out it wasn't his, right? Am I right? Somebody help me out. Thank you, Holly. Yes, right? And first of all,
you pay child support for 18 years, and on your 18th birthday, you find out it isn't his.
Thank you. But by the way, the next line is holler, we want prenup, but a prenup would not be valid, right, for child support. So Kanye, call me. I would have advised you on your lyrics. But you get the point here that this is an incredibly fraught document. Okay, but this is a real path to non-marital parentage. The next question would become, and this is a huge issue in Kentucky, is in a state like Kentucky that keeps gendered language for its presumptions, could a woman sign this who is bedside to a woman giving birth? So could a same-sex non-biological or non-birthing mother establish motherhood through this document? In Kentucky, the document is still gendered masculine. And so very real question of whether if a mother signed this, it would be valid. Okay, next. I am going to come to Annie next, and we're going to talk about the Parentage Act. The Parentage Act, if you have the new book, the original one is on page 436. Anyone who has the old book, someone type in the comments what page this is on, because you should tab it. This will be one of the possible jurisdictions you could be tested on the exam. Thank you. So page 447. Okay, so Annie, tell us, so under the Parentage Act, so the Parentage Act is basically enacted isn't the right word, is basically written, it's a uniform act. It's not a federal law. It's an act that various states can adopt. And so Annie, tell us generally what this says. Is she here? Why do I not see anything? I don't think she's here.
She's not here, no.
Okay, thank you. Okay, well, I'm going to tell you guys super quickly what this says. Maybe I have a slide. Well, I'll go to Kim since I got Beyonce too. I got all the ladies in the house tonight. Okay, this is the way what this Parentage Act tells us is you become a parent, a mother by birth, and you become a father by marriage. So all my pop culture fans, tell me why I have this picture up. How does this review for us the marital presumption of the original Parentage Act? DJ.
Whoop, whoop. Kim was technically still married to Chris Humphries while she was pregnant with Kanye's baby.
Good. So legally, who was the father until established otherwise?
Chris Humphries.
Chris Humphries. Everyone agreed, including Humphries and Kanye West, that it was Kanye's baby. But because she was legally married under the Uniform Parentage Act, Humphries was presumptively the father until someone challenged. So a presumption is a starting point until someone challenges otherwise. So in this particular case, of course, Kanye would have come in and challenged otherwise. But some of you might remember this moment. It was probably right before you came to law school, where a bunch of fun little tabloid magazines were like, fun fact, Kanye's baby is really Chris Humphries, that drew out this point. So this point is called the marital presumption. And it is still the dominant approach in Kentucky and in most states for how we establish paternity. You become a father because you are married to the woman who gave birth, which brings me, wait for it, to my rewrite of the Beyonce lyrics. Oh, if you want to parent it, put a ring on its mama 300 days before birth. Oh. You're welcome. That's our marital presumption. Now, the next question, I don't know how I could embarrass myself any further. I've hit rock bottom. Okay, so the next question is how else can you become a father? So if you're looking on page 447 of the old book or page 436 of the new book, the other way that I want to bring your attention to become a father, 1 is marriage, 2 is the voluntary acknowledgement of paternity, and 3 is what's known as the holding out presumption. And so it's subpart 4, which in my book is 437. Somebody maybe can point out, but it's subpart 4, wherever you are. And it says that a father can also become a father because while the child is under the age of majority, he receives the child into his home and openly holds out the child as his natural child. So that's 3 ways to become a father: marital presumption, the voluntary acknowledgement of paternity, which is fraught with risk and really manipulates a very emotional moment in a putative father's life. Or 3, while the child's under the age, he holds the child out as his natural child. That's in the original UPA, which is from 1972. And so that's the original. It's also, Mary Beth, all 3 things that I'm describing are in all of the UPAs, but this at the original UPA had only these things, but all the way through to the modern UPA has both the marital presumption, a holdout presumption, and a voluntary acknowledgement of paternity. Cool. But the one thing I want to mention, because Mary Beth's questions is saying, the other ones add more, but they don't take away, except for one critical thing. So the old UPA, which is what Kentucky has, says you take the child into your home and openly hold it out, and there is no date restriction on that. If you flip ahead to the modern UPA, either the 2002 one, which you would have if you have the old book, or the 2017 one, which you would have if you have the new book, either of them instead say that you can only hold out a child as a parent or as a parent in the first 2 years of life. So going back to our Clark v. Jeter case, in that case where bio dad doesn't find out he's actually biological dad until after 2 years, he is out of luck for the holdout. Michael H., out of luck for the holdout. It's only those first 2 years. Why does that matter? Because if the putative dad doesn't know he's the dad until after that, we're kind of out of luck. Which brings us to my favorite case in all of family law, which is either Wallace v. Smith, or PPVDD, depending on which book you're using, but they're the exact same. And so under these rules that I'm describing, let's get into this. Elizabeth, let me come to you. Which book do you have, Elizabeth? Are you using Wallace?
Yes, Wallace.
All right, tell us. This is my favorite case. No pressure. It's the best one in the whole book.
Okay, so basically we have Wallace and Smith who were in an intimate sexual relationship. They discussed birth control, and she agreed that she would use birth control, and that they both agreed that they would only be in the relationship for as long as she was on birth control. At some point, she changed her mind and stopped taking birth control without telling him, and then she gave birth to a normal, healthy girl. And then Wallace sued Smith for money damages. So he's using contract law here. Very nice. He asserts 4 causes of action: fraud, breach of contract, conversion, and prima facie tort. And then the district court dismissed his claim for failure to stay, and Wallace appealed.
Good. For those of you who I hadn't towards the the conversion stuff, do you realize what is she saying? What is she saying?
Sperm.
She's saying he converted his sperm. He took it as his own. She took it as his own. I can't talk. She took it as her own and made it her own. That's the best. You should curse me for whatever boring conversion class I used to teach it. This is way better. But this is like a beautiful example of family law, contract law, and courts all coming together. Now, he sounds like kind of an asshole, right? He's actually a law partner. She's actually a secretary at the law firm. Like, the whole thing makes him sound pretty selfish and terrible. So I'm going to have us actually empathize deeply with this man. So let's talk for a moment, and let's just do it in the chat to get to keep everybody awake over here. What's actually at stake for him? Why would he care so much? Let's specifically try to imagine, like, if we could wave a wand, what are the most compelling set of facts I could tell you about him that would make us empathize deeply with him? Why might he want to control his reproduction? Why might he not want to become a parent? What are the costs that he's experiencing here? Good. So he might be married. He might have another family. No, I'm really seriously trying to empathize with him, though. Yes, good. DJ says he might have a genetic history that makes him not want to have children. Good. He might have a genetic condition, genetic disorder. He might have, I already told you he was a law partner. That was kind of unfair. But he might not have been able to support the children. He might be older. Good point. And by the way, we have all sorts of medical frames where we demonize women who we threaten women because they're having children later in life. There's all sorts of new research suggesting that men's sperm later in life might also be fraught and problematic. And so here he might be older, he might not want to be a parent at that age, or might not be able to be the healthiest parent at that age. He might not be able to financially raise the child. I sort of ruined it by saying he was a lawyer, but this is a real point. If we go back to Zablocki from last class, where he said you wouldn't be allowed to marry unless you could prove that none of your children would be a public charge. Also, like Michael says, he might actually just not want to have children. He might want to focus on his career or have other children from another marriage that he wants to support or take care of. There's any number of incredibly compelling reasons why he might want to control his reproduction. And in doing so, when I read this case, I mean, on one read, he looks kind of like a jerk, but on the other read, he looks pretty out of the box, right? Like, these are not easy conversations to have. He had a very clear conversation expressing Juanita, the court is with you on this, expressing his wishes, his intent, and the court, Monica, let me come to you. I think I have you for this case as well. Monica, what does the court tell him? So he's coming to the court. He's got these contract theories. He's effectively trying to be made whole for the child support he could be charged with, but he's not actually been found to owe child support officially. How sympathetic is the court, and what does the court tell him about these claims?
So the court is not very sympathetic at all. First, it points to the UPA, saying that it's like a form of strict liability, and lists all the justifications pointing to public policy as to why he needs to be held responsible for the child, even if he didn't want to have the child in the first place. Then they discard the whole fraud allegation and say that no jurisdiction really recognizes contraceptive fraud. And then when they point to the contract principles, they pretty much just said there's still a child and the child still has needs, so it needs to be covered.
Good. And the key thing that I think is so interesting is this Uniform Parentage Act that we're studying. It's all about who is a parent. And if you are found to be a parent, the support, that's a strict liability framework. And that's exactly what Monica said. Why is that so interesting? It's so interesting, I think, because if we go back to these different frameworks for how we can think about parentage, many of us I think a lot of folks' first reaction is that intent is a pretty flexible way to think about parentage. It would work with artificial reproductive technologies, assisted reproduction, where you can say, well, I'm going to carry the child, but you intended to take the child after birth, so that intent should govern. It would work with same-sex couples where, mom has bio-mom has insemination, but non-bio mom intended to also be a parent. And intent seems so flexible, like it could easily work with almost every circumstance. But it's these cases, these child support kinds of cases or non-marital father cases that make a lot of states reluctant to go with intent. And the court says here, even though he made his intent clear quite crisply, he did a brilliant job of, asking for what he wanted. And the court says this is not how it works, that parentage is a strict liability frame. So that's why when we go back to like the holding out presumption, where we say only holding out in the first 2 years, you might say, well, isn't that unfair? Because what if the putative father didn't even know he was a father, like the facts in Clark v. Jeter? But the state's answer to that really kind of sits in Wallace v. Smith and says, you should have known you were a father the moment you engaged in sexual conduct, and that otherwise that we're going to hold you strictly liable. So this case and these kinds of cases raise a ton of controversy in men's rights communities, particularly. I'll tell you, there are even a couple, not a lot, but there are even a couple of cases in which there are rapes involving a female rapist. These are mostly having to do with age and consent, but a rape case involving a female rapist where the male victim has even been found to owe child support, even if he didn't even voluntarily or wasn't even of age to consent to the sexual conduct. So incredibly sweeping strict liability frame. And the only way we can really, really understand what's happening here is if we go back to an entire history up until the 70s of non-marital fathers having no rights or responsibilities with respect to their kids. We've swung way far the other way. Let me come to Stanley next, and let me come to Juanita. So why don't you tell us what happened here?
Oh, Stanley?
Yeah.
Okay. Well, Joan and Peter Stanley lived together intermittently for 18 years and had 3 children. When Joan died, they were not married. When Joan died, Peter lost his children because they had not been married. The children were declared wards of the state, and Stanley appealed, claiming that he had never been shown to be an unfit parent, and without such a showing, he had been deprived of equal protection guaranteed by the 14th Amendment.
Good. And he also has a parallel procedural due process claim. What procedure does he say he was deprived of?
Something proving, an investigation proving that he was an unfit father.
Good. And if you're reading this, I mean, the gendered implications of what this legal framework is saying are pretty staggering. First of all, just pause for a moment. Did everybody catch it was Joan and Peter Stanley, but they're not married? They just happen to have the same last name. Anyway, just fun fact. But they were never married. They do just happen to have the same last name. So he's saying that he should have been given a hearing or an opportunity to be heard as well. But just process this. If this had been a neglect proceeding, he would have had a hearing to declare him unfit. If he had been married and his wife died, he would have immediately gotten the kids. If he had been married and a woman, right, and the husband died, then he would have automatically gotten the kids. Even if it was an unmarried woman and the father died, she would have automatically gotten the kids. Like, if we pause it, and as you guys are studying child custody this week, and you think about the gendered biases and subjectivity that sits in child custody, think about what this law is saying. It's basically saying that because he was an unfit father, he was presumptively unfit. Like, that is such a staggering gendered revelation for the state to put forward. It should catch all of our attention. However, I'm about to bust this case for all of us because it sounds so compelling, and Ethan and Juanita are going to tell us all about the holding, and it's lovely. But the real story, the backstory of this case, is that after Joan died, he actually immediately took the kids to someone else to care for them. And he was not actually caring for the kids at all. They weren't in his custody at all. However, the children were receiving public benefits. So the check for the public benefits was coming to Peter. The children were no longer with Peter, and the state got involved for that reason. So yet another example. It's terrible facts because the court here is trying to lift up non-marital fathers and debunk these myths and stereotypes. And tragically, he's not actually the person to properly debunk these stereotypes. And if you read it, I love how Juanita read the first sentence. All it says was, hey, he lived intermittently with Joan and they had these 3 children. It tells us nothing about him as a parent or these, any sort of meaning and relationship that he had with the kids. It's really more of like a welfare fraud case. But again, it reveals for us how we cannot understand child support or parentage without understanding the massive federal power trying to recoup federal welfare expenditures back to the state. So Ethan, we've got this equal protection argument and we've got a due process argument. What does the court do with these two causes of action?
So the court says that father was entitled to a hearing, both on his fitness as a parent before the children were taken from him, and by denying him a hearing when all other parents who would have custody of their children and could challenge it are permitted one, they denied his equal protection under the law of the 14th Amendment.
Beautiful.
Yep.
Good. So both are procedural due process, and we know it's procedural due process when we're asking for a protection, not about parenting. It's about just, you can't take away my right to parent without a hearing, and equal protection. And what standard of review, Ethan, does the court apply?
I'm always terrible at this kind of stuff. This is the hardest thing I have with law school. Believe it's is it strict scrutiny? Strict scrutiny. Heightened scrutiny. Yeah, I don't know. We need to help a brother out.
I don't. They said something about rationally related. Wait a minute. Did they? Well, I was thinking intermediate scrutiny, but I think maybe it was.
You're exactly
rational basis.
Yes, and yes, that is brilliant. You're exactly right. It is that the court saw this as a legitimacy classification, which should get intermediate scrutiny, meaning the government has to show an important government interest and that the means are substantially related. However, the court actually said, kind of like it did in Loving, we don't even need to go there. This isn't even rationally related, because the government was supposedly acting to protect child welfare, and you're not helping any child if you keep a child from a parent without a hearing when that parent could have been a fit parent. But I think it's important to have this little backstory point about the case, because he's not a very redeeming father factually. In this case, if he were, you would read this very differently, and it would talk about what was lost for him, and it would read a little bit more like kind of the dissent in Michael H. But ultimately, another reminder of procedural due process governing parentage and family relationships. Another reminder that we apply heightened scrutiny to legitimacy classifications. Next, let's look at Michael H., another great iconic family law case. And I have Dimitri first for this.
Hello, Professor. All right. I was hoping I didn't have to do the facts, but it's cool. So it all happened pretty fast. It was about a 5-year time period. Starts in 1976, where Carolyn D. and Gerald D. were married. Gerald D. was a top executive for a French oil company. I don't know if y'all need that. So in the summer of 78, Carol became involved and had an adulterous affair with the neighbor Michael H. In 1980, she conceived the child Victoria D. And in 1981, Victoria D. was born. Gerald was listed as the father on the birth certificate and held out to the world that Victoria was his daughter. And then in October of 81, Gerald moved to New York to pursue business interests, but Carol and Victoria stayed in California. At the end of that year, Carol... Oh, did I bring Michael in yet? Did I say? Oh yeah. Okay. Yeah. I said she had an affair. Okay. So,
Adults with affair.
at the end of that October 81, when Gerald moved away, Carol told Michael had a blood test, and it showed that he was like pretty much the baby's dad, if you want to say it like that. So 98% probability that he was the father. In January of 1982, she went and hung out with Michael in St. Thomas for like 3 months, and Michael held Victoria out as his child. Then she left in March, went back to California, stayed with another man named Scott Kay. I don't know how important he is. And then in November 1982, Michael filed for a fellation action, and I wanted to say something else on that, but in March of 1983, the court appointed an attorney and guardian ad litem to represent Victoria's interests in this action. And then she also filed a cross complaint, but I feel like I'm digging too deep into the facts. And then in May 1983, Carol filed a motion for summary judgment. During that time, March through July of 83, which is 2 years after Victoria was born, Carol was again living with Gerald in New York. In August of that year, she went back to California, became involved again with Michael, and then instructed her attorneys to remove the summary judgment motion. And then for 8 months, I think when Michael wasn't away in St. Thomas, they were like together, I guess, in Carol's apartment in LA, and then he held Victoria out as his daughter. And then in 84, Carol and Michael signed a stipulation that Michael was the natural father. Carol left Michael the next month, and then she instructed her attorneys not to file the stipulation. So then June 1984, she reconciled with Gerald, which she's been married to this whole time, and joined him in New York, and now they live there. And then Michael was like, okay, well, I'm going to file some stuff, and so now we're taking this to the Supreme Court or wherever. And I could keep going like deeper.
No, you crushed it. In fact, you just broke like an actual family law record of being on call for longer than probably anyone in our summer class. So good job. So beautiful summary of the facts. And all of that stuff really matters against the backdrop of the Parentage Act. So under the Parentage Act, Dimitri, if he, from the law side, could have stopped when he said the baby was born, it's Michael's biologically, but it was born in marriage. She's married to Gerald, therefore it is Gerald. So everybody see how incredibly simple it is under the presumptions, because it's a conclusive presumption, which is very different than a rebuttable presumption. So Dimitri gave a beautiful in-depth summary of the facts. The law is this: Carol was married to Gerald D. Gerald D is the father. Michael H. didn't come forward soon enough. Michael H. has no claim because of the Parentage Act. And so the Parentage Act here is very important because it doesn't allow, after this very limited window, any ability of Michael H. to come forward. Mary Beth, let me have you come in for a second and let's talk about Victoria. So far in parentage, we haven't really mentioned the kid at all. What is the kid's argument here? Because she's also in the case. So Michael H. wants visitation, as Dimitri tells us. Mary Beth, what does the kid want?
So Victoria, through her guardian ad litem, sought visitation rights for Michael. And said, I think, where did it say? It said she wanted to maintain her relationship with him as a father figure.
Good. So they're really bringing this together. And notably, it should catch your attention because we've not talked at all in family law about the rights of children to have a relationship with their father, with their biological parent. And so that's what she's seeking. Mary Beth, why can't she get that? It seems perfectly obvious that if both have had a relationship, and if the kid wants to keep a relationship with both, why can't they both be fathers? What's holding the court back?
They said, I think if I remember correctly, that there was no historical precedent that said that you could have a dual fatherhood relationship with a child. And then also they take into account the fact that she was living and residing with, who was it? Gerald and Carol. So they were saying that, well, just because you want a relationship with Michael, technically and legally, you are the child of Carol and Gerald because of their marital relationship.
Good. And the key fact that needs to be said, because it's true in Kentucky and it's true in every state except California and maybe one other, is there's only room for one father. Two parents. In some jurisdictions now would allow those two parents to be of the same gender, not officially, not Kentucky under its parentage laws. You can through adoption and contract. But here the court is saying there can only be one father. Carol's the mother, Gerald's the father, presumptively. Michael H. showed up too late and there was only one seat to be taken. And what does California do after that, Mary Beth, to address that logical limitation on the court's reasoning? Or anybody who caught this. It's in the notes.
Oh, maybe.
Even if you didn't catch it in the notes, what could you legislatively do to fix the problem that set up this oddity in Michael H?
Make it less gendered?
Make it less gendered or make more seats at the table. And so afterwards, California, in direct response to this case, actually amended its law and said, you know what, there can be two fathers, there can be three parents, but not four, right? And then, of course, there are plenty of other circumstances where you could have, you could argue that the limit on three is too little. Okay. Dimitri, what's the court's holding on, is there a due process right at all? So normally we go into the means and are the government's interest, but is there even a fundamental right affected here in Scalia's analysis?
No, basically solely on history, and the dissent didn't really like that at all. They were kind of pissed.
Good. And the history, let me come to, I think I have Davis on call for this too. Davis, what is specifically what history, what is the court protecting here? What's the court's not protecting the parent-child relationship with the biological child? What is the court protecting instead?
They're protecting marriage. Oh, do you want me? I'm sorry.
Yeah, either one. Davis, why don't you jump in? But you're exactly right, Dimitri.
Yeah, so basically what Dimitri just said. And it's just like, as you said, the kind of the traditional aspect of there being just two parents and not enough seats at the table for more than that.
Good. And so what the court is saying here, it cannot be said bluntly enough. What the court is saying here is it's more concerned with protecting the quote unquote sanctity of Gerald D. and Victoria. I'm sorry, that's creepy. Of Gerald D. and Carol than allowing the relationship between biological dad and daughter to flourish. That the value that the court sees is the one that we have traditionally always protected in our law, in Justice Scalia's analysis, is the child that came out of a marriage. Even if that child is not genetically the child of the father, that's what we historically and traditionally protect. My favorite wording of this, not favorite in a good way, but noteworthy, is the court calls him a marital father. Like, just stop and process that idea that we have a biological father who's been kicked out and has zero rights to a relationship because of what we're calling a quote unquote marital father. And it's just really interesting if we connect this to like our human ways of thinking about fatherhood. Like, you'll find a ton of really interesting Father's Day cards that say you've always been like a dad to me. Thanks for stepping in and being, like a father. But this idea of like a marital father is not, I think is a very, very interesting way to think about this. but it's a very narrow construction of fatherhood. And that's what the court is protecting over the biological relationship of a genetic father to a child with whom the child is pleading herself for a relationship with. Okay, let's jump ahead. And so the court strikes this down, and it strikes it down without even seeing a fundamental right at all. There is nothing here to even be protected, because we're going to protect Gerald D. and Carol's marriage so heavily, even though it was clearly a flawed marriage. Olivia, let me come to you with the dissents. What did the dissents say?
So the dissents say that it's wrong to foreclose the possibility that a natural father might have a constitutionally protected interest in his relationship with a child, and that nothing in the court's precedent requires a constitutional principle to be entirely based on just traditional common law concepts.
Good, perfect. And so the court here is super concerned with this narrow framing. It really views families as far more diverse, far more grounded in relationships. But if we go back again to this idea of all these different ways we can think about who is a parent, the court is unequivocally privileging the marital father, quote unquote, over genetics, over relationships, over intent. It's a really staggering opinion for us to process for the purposes of understanding family law. We have one case left, and I'm gonna come to Holly to give us the facts, and then I might expedite us through because I want to make sure I get you out of here on time. But Holly, tell us what happened in Chatterjee. Oops. Holly? Okay. I am going to just summarize this case because I want to make sure we bring this out a little bit, because the question that sits before us is, what are we going to do with same-sex parents? Coming out of Obergefell is all this beautiful language about how important it is that the children of same-sex couples get the dignity and recognition that the children of opposite-sex couples get. But remember, Obergefell, in doing so, is sort of stigmatizing non-marital children, which should catch our attention with the history we covered today. But in Chatterjee, we have a same-sex couple. One member of the couple, King, adopts a child from overseas, and that formal adoption is in one of the two parents' names. So if we think about parentage by biology, neither of the two partners would be parents. If we think about it by contract, King alone would be a parent. If we think about it by intent, both King and Chatterjee would be a parent. And if we think about it by social stuff, like who puts the kids to bed and takes them to the doctor, both of the parents would be recognized as parents. And so we can see this fluidity of like which rule we pick. And so the same-sex partner comes forward and she says, I get to be a parent, even though I'm not legally the adopted parent, because I took this child in and I held the child out as my own. That's using the UPA that we studied. So she held the child out, said, this is my child, and therefore she should be a parent. The lower court, though, if we go back to my chart from the beginning when I was showing you the way you become a mother and the way you become a father, the trial court said, ooh, so sorry, holding out is a way you become a father. You can't be a father, you are trying to be a mother. And that's what the trial court took that gendered language very explicitly. On appeal, the court says that's not how this works. This is really about functional parentage. If you hold the child out as your own without regard to gender, you can establish a parent-child relationship that way. And that is how the most recent version of the UPA approaches it. The last thing I'll say is that Kentucky has not clarified yet how it will handle these gendered terms in our parentage laws. And so huge questions of whether we need to rewrite our laws or make them gender inclusive without rewriting them. So I'm going to stop there. I'm going to email you guys later tonight with a couple things. I'm going to email you to clarify what to do for next week because I need to trim down a little bit for next week. I will start next week with some review of parentage. We covered a lot. It was kind of a little bit of a dense class, so I want to make sure we review it more dynamically. And then 3, I'm going to send you guys a quick little recap of the key themes from tonight just to make sure it all pops for you. But great job for everyone who was on call. I really appreciate your engagement. But I'll make sure by the end of next class that we feel really good about this material and we've had the chance to apply it. For the exam, you could be tested on the old UPA or the new UPA, either one. And so we'll talk more about that next week. So I'm going to officially stop class, but I'm going to stay on as long as needed and answer any questions whatsoever or chat about any celebrity marriages and parenting relationships. Ethan.